Where are you headed tonight?
Just driving home to South Carolina, sir.
Mind if I take a look inside the vehicle?
No, sir, I'd rather
You
not.
sure about that? We got information there might be drugs in this car.
Drugs? No, sir, there's nothing in my car.
You mind stepping out of the vehicle?
He had just bought a brand new Mercedes convertible. He had the paperwork. He had the title. He had the keys. He was driving home from a vacation, minding his own business, on a dark Mississippi highway, when the blue lights came on behind him. The officer ran his ID, came back clean. He ran the car's records. They confirmed Jameson owned it outright. Everything checked out. There was nothing, not one single thing that justified what happened next. The officer looked at Clarence Jameson, a black man in a nice car, and lied. He told him police had received a tip about 10 kilograms of cocaine hidden inside the vehicle. He asked to search the car. Jameson said no. He asked again. Jameson said no. He asked 5 times. For nearly 2 hours, on the side of a busy highway in Mississippi, a black man stood in the dark while an armed officer tore his brand new car apart, looking for drugs that were never there. The dog found nothing. The search found nothing. Because there was nothing. There had never been anything except a black man in a Mercedes on a Mississippi highway, and an officer who had already decided that combination was suspicious enough to destroy. And then 7 years later, a black federal judge got the case. And what he wrote will never be forgotten. Before we dive deeper into this absolutely shocking story, hit that subscribe button if you believe in holding authority figures accountable when they abuse their power. Clarence Jameson was not a millionaire. He was not a celebrity. He was not a politician or a professional athlete or anyone whose name you would have known before this story. He was a welder from Neeses, South Carolina, a small, quiet community where everybody knows everybody and a man's reputation is built slowly, with his hands and his word. He worked hard. He saved carefully. And in July 2013, he did something he had probably been planning for a long time. He bought himself a 2001 Mercedes Benz convertible from a dealership in Pennsylvania. Not brand new off the lot, but his. Clean title, good condition. The kind of car that represents something, not just transportation but arrival. The quiet, personal announcement that says, "I worked for this and I earned it." He drove that car to Las Vegas. He drove it to Phoenix, Arizona. He took his vacation. He lived his life. And on the night of July 29, 2013, he pointed to Mercedes East and started the long drive back home to South Carolina. He never could have imagined what was waiting for him on Interstate 20 in Peelahachie, Mississippi. It was dark on Interstate 20 when Officer Nick McClendon of the Richland Police Department pulled Clarence Jameson over near Peelahachie, Mississippi, a town about 25 miles east of Jackson. McClendon was working in Peelahachie under a mutual aid agreement that allowed him to patrol outside his home jurisdiction. He later said the temporary tag on Jameson's Mercedes was hard to see. That was the reason. A tag on a car being driven by a black man returning home from vacation in a state where, as federal Judge Carlton Reeves would later write in a devastating opinion, a black man driving a nice car was apparently reason enough. McClendon ran Jameson's identification. Came back completely clean. No warrants. No criminal history. No flags of any kind. He ran the car's records. They confirmed Clarence Jameson was the legal owner of that Mercedes convertible. Everything checked out. There was not a single legitimate reason to take this stop any further. Any officer acting in good faith would have handed back the documents and sent him on his way. Officer McClendon did not send him on his way. What Officer McClendon said next was not a mistake. It was not a misunderstanding. It was, as federal Judge Carlton Reeves would later conclude in his written opinion, a lie. McClendon told Clarence Jameson that his department had received a phone call reporting that Jameson's vehicle contained 10 kilograms of cocaine. 10 kilograms. Hidden inside a car that had just been searched on record, confirmed as legally owned, and driven by a man with no criminal history whatsoever. Jameson knew it wasn't true, because it wasn't true. There was no cocaine. There had been no tip. There was no phone call. There was a black man with a nice car on a Mississippi highway, and there was an officer who had decided that was enough. Jameson said no to the search request. Clearly, directly. McClendon asked again. Jameson said no again. The task came again, and again, and again. 5 times, Clarence Jameson told an armed police officer no. 5 times. What happened after that 5th refusal reveals exactly how much that word no meant to Officer McClendon. After 5 refusals, something shifted on that dark Mississippi roadside. Clarence Jameson was standing outside his car, in the dark on the shoulder of a busy interstate, with an armed officer who had already lied to him once and showed no intention of letting him leave. The power imbalance was not subtle. It was total. Jameson was alone. McClendon had a badge, a gun, and the full weight of the state of Mississippi behind him. And federal Judge Carlton Reeves would later write words that cut to the heart of that moment. Who can say that Jameson felt free to say no to an armed officer McClendon? Who can say that he felt free on the side of Interstate 20? The answer is nobody. Nobody can say that. Because Clarence Jameson, a black man in Mississippi, on a dark highway, in 2013 was not free in any meaningful sense of that word. He eventually said yes to the search. Not because he consented freely, but because he understood, in the way that black people in America have always understood certain things, that saying no a 6th time might cost him far more than his dignity. What Officer McClendon did to that Mercedes next left $4,000 worth of damage and 0 grams of cocaine. Officer McClendon searched the car. He went through it thoroughly top to bottom, front to back. He found nothing, because there was nothing. No cocaine, no drugs, no contraband of any kind. He found a legally purchased vehicle, owned by a law-abiding man, who had committed the crime of driving while black through the state of Mississippi. But McClendon was not finished. He called for backup. And with backup came a canine unit, a drug detection dog brought in specifically to sniff through Clarence Jameson's Mercedes convertible for evidence of the 10 kilograms of cocaine that McClendon had already claimed existed. The dog found nothing. Of course it found nothing, because there was nothing to find. There had never been anything to find. The tip was a lie. The cocaine was a fiction. And now a man who had simply been driving home from his vacation stood on the side of a busy Mississippi highway in the dark for nearly 2 hours while an officer used every tool available to him to find a crime that did not exist. And what Clarence Jameson was eventually forced to do on that roadside is the detail that should make every single person reading this stop and breathe. 110 minutes. That is how long Clarence Jameson stood on the side of Interstate 20 in Peluhatchie, Mississippi. Nearly 2 hours. On a busy highway, in the dark, with no place to go literally. At some point during those 110 minutes, Clarence Jameson needed to use the bathroom. He was not near a rest stop. He was not near a gas station. He was on the shoulder of a Mississippi interstate, being held in place by an armed officer who had lied to him, searched his car, brought in a dog, and found absolutely nothing. Jameson was eventually forced to urinate on the side of the highway, in public, with nowhere else to go and no permission to leave. When this detail appeared in Judge Carlton Reeves' 72-page opinion, it landed like a punch. Because it was not incidental. It was the distilled essence of what that stop was really about: the complete removal of Clarence Jameson's dignity, his autonomy, his humanity, 1 hour and 50 minutes at a time. When McClendon finally finished, what he left behind told the whole story. When Officer McClendon concluded his search, having found nothing, confirmed nothing, proven nothing, he did not apologize. He did not offer assistance. He did not acknowledge the lie he had told, the time he had taken, or the damage his search had done. He left. Judge Carlton Reeves described it plainly in his opinion. Nearly 2 hours after it started, the officer left Jameson by the side of the road to put his car back together. Put his car back together. Because the search had left the interior of the Mercedes in a state of disarray. Seats disturbed, panels pulled, compartments opened and not fully restored. The final assessment of the damage to Clarence Jameson's car came to over $4,000. The car he had saved for. The car he had driven to Las Vegas and Phoenix. The car that represented something real and personal about who he was and what he had built. An officer had lied to search it, found nothing, and left him alone in Mississippi in the dark to reassemble it with his own hands. Jameson drove home. 3 years later, He did something that would eventually land on the desk of one of the most remarkable federal judges in America. Clarence Jamison filed his federal lawsuit in 2016, 3 years after the stop. He sued Officer Nick McClendon under 42 U.S.C. Section 1983, the federal civil rights statute passed by Congress during Reconstruction specifically to protect the rights of Black Americans from state-sanctioned abuse. His lawsuit argued that McClendon had used his race as a motivating factor in the stop and search, violating his 4th and 14th Amendment rights. The case moved slowly through the federal court system the way civil rights cases often do, carefully, deliberately, with the weight of legal precedent pressing down on every motion. Eventually, the case was assigned to the United States District Court for the Southern District of Mississippi. And the judge assigned to hear it was a man whose life story, whose background, and whose understanding of exactly what had happened on that Mississippi highway that night would make what came next one of the most extraordinary judicial opinions in modern American history. His name was Carlton W. Reeves, and he was about to make the entire country listen. Carlton Wayne Reeves grew up in Yazoo City, Mississippi, rural, small, and shaped by the full weight of Mississippi's history. He was one of 7 children. He was the first person in his family to attend a 4-year college. As a teenager, he cleaned the office of a federal judge named William Barber, a man he would eventually replace on the federal bench. He graduated magna cum laude from Jackson State University. He earned his law degree from the University of Virginia. President Barack Obama nominated him to the federal bench in 2010. He became only the 2nd African-American federal judge in the history of the state of Mississippi. Judge Carlton Reeves knew Mississippi. He had grown up breathing its air, walking its soil, studying its history, the lynchings, the black codes, the massacres, the generations of black lives crushed by the very law enforcement system that was now standing before him in the case of Jamison v. McClendon. He understood, from the inside, exactly what had happened to Clarence Jamison on Interstate 20. And he was about to write about it in a way that no federal judge had ever quite written before. But first, he had to do something that would test every principle he had spent his career defending. On August 4, 2020, Judge Carlton Reeves issued his ruling in Jamison v. McClendon. He found that Officer McClendon had flagrantly disregarded Clarence Jamison's 4th Amendment rights. He found the search was the result of coercion, not genuine consent. He found in plain, unambiguous language that what happened on that Mississippi highway was a civil rights violation. And then he granted Officer McClendon qualified immunity and dismissed Clarence Jamison's lawsuit. He was legally required to. Qualified immunity, the controversial doctrine that shields police officers from civil lawsuits unless a prior court case has already deemed identical behavior unconstitutional, left him no choice. The Supreme Court's precedent was clear and binding. No prior case placed McClendon's specific conduct beyond legal debate. And so Judge Reeves, who knew exactly what McClendon had done, who had written it in his own words, who had called it what it was forced by the law he was sworn to uphold to let the officer walk away without consequence. But Judge Carlton Reeves was not finished. Not even close. Judge Carlton Reeves did not simply issue his ruling and move on. He wrote 72 pages of a legal opinion that began with the ruling the law required and then became something else entirely. A full historical reckoning with race, policing, qualified immunity, and what it means to live in a country that promises equal protection and then builds a legal doctrine to ensure that promise cannot be enforced. He opened with a list. Not a legal argument. A list. He wrote what Clarence Jamison was not doing the night he was stopped. He was not jaywalking, that was Michael Brown. He was not playing with a toy gun, that was 12-year-old Tamir Rice. He wasn't suspected of selling cigarettes, that was Eric Garner. He wasn't suspected of passing a counterfeit bill, that was George Floyd. Then he wrote the sentence that traveled across the entire world. No. Clarence Jamison was a black man driving a Mercedes convertible. That was it. That was the only crime. A black man. A Mercedes. Mississippi. And 110 minutes of a man's life stolen at gunpoint on the side of the road. What Judge Reeves said about qualified immunity next was so powerful that attorneys floated his name for the Supreme Court. For words. 11 syllables. Judge Carlton Reeves wrote them in the middle of his 72-page opinion, and they became the headline of every legal publication in America. Immunity is not exoneration. He said it clearly for anyone who had ever confused the two. Getting off on a technicality does not mean you did nothing wrong. Qualified immunity does not mean McClendon was right. It means the law as constructed and expanded by the Supreme Court over decades did not provide the mechanism to hold him accountable. Those are two completely different things. And Judge Reeves refused to let the distinction disappear into the language of the ruling. He went further. He called on the Supreme Court directly, in a published federal opinion, to eliminate the doctrine of qualified immunity entirely. He compared it to the doctrine of separate but equal. He said the status quo was extraordinary and unsustainable. He said, "Let us waste no time in righting this wrong." A sitting federal judge, in a binding legal opinion, challenging the highest court in the land to do better. In Mississippi, in 2020, the legal world had not seen anything quite like it, and the public reaction was immediate and overwhelming. The opinion was published on August 4, 2020, in the middle of a summer when the entire country was reckoning with police violence after the death of George Floyd. The timing was not lost on anyone. Legal scholars called it a must-read. Law professors assigned it in classrooms within days of its publication. One legal writer compared it to the great dissents written by Supreme Court justices' opinions that lose in the moment but define the future. CNN quoted it. The Washington Post ran a full analysis. NPR interviewed legal experts about its implications. Attorneys across the country posted sections of it on social media. Austin Sherratt, writing in Justia, said Judge Reeves' opinion was extraordinary not just for its legal argument but for its humanity, for the way it refused to let Clarence Jamison disappear into a case number and a ruling. For the way it said his name, described his car, honored his vacation, acknowledged his dignity, and then named precisely what had been taken from him on that dark Mississippi highway by a man with a badge and a lie. But while the country was reading Judge Reeves' words, Clarence Jamison was sitting at home in South Carolina with no compensation, no justice, and an officer who had faced no consequences. This is the part of the story that has to be said out loud, clearly and without softening. Clarence Jamison got nothing. His lawsuit was dismissed. Officer McClendon received qualified immunity. No discipline was publicly reported. No compensation was ordered for the $4,000 in car damage. No acknowledgement came from the Richland Police Department. No apology was issued. The 110 minutes stolen from him on the side of Interstate 20 were not returned. The humiliation of being forced to urinate on a highway while an officer searched his lawfully owned car for drugs that didn't exist that was not compensated. The lie McClendon told him, the 5 refusals he overcame through pressure and intimidation, none of it produced any consequence for the officer who did it. Judge Reeves had said it himself, immunity is not exoneration. But for Clarence Jamison, in practical terms, the difference between immunity and exoneration felt invisible. The officer walked away. The man with the Mercedes went home. The system had worked exactly as it was designed to work. But something was already moving, quietly, that would ensure McClendon's name and Jamison's would never fully disappear. Within months of its publication, Judge Reeves' 72-page opinion in Jamison v. McClendon had become required reading at law schools across the United States. Not as a footnote, not as a supplementary source, as a primary text assigned alongside Supreme Court opinions and landmark civil rights cases in courses on constitutional law, civil rights law, police accountability, and criminal procedure. Law professors used it to teach qualified immunity. They used it to teach the history of policing. They used it to teach the gap between what the Constitution promises and what the legal system delivers. Clarence Jamison, the welder from Neeses, South Carolina, who bought a Mercedes and drove home through Mississippi, became a figure studied by thousands of future lawyers, public defenders, prosecutors, and judges who will carry his story into every courtroom they ever enter. The man who got nothing in court became the man who taught a generation of legal professionals why that outcome was wrong. And then Congress began to move, and the connection to Jamison's case was impossible to ignore. The summer of 2020 produced a serious congressional push to end qualified immunity as a national legal doctrine. The George Floyd Justice in Policing Act passed by the House of Representatives in 2021 included a provision that would have eliminated qualified immunity for law enforcement officers in federal civil rights lawsuits. The bill cited patterns of racial profiling and documented cases of officers escaping accountability through the doctrine. Judge Reeves' opinion was referenced in congressional debates. Legal advocates testified about cases exactly like Clarence Jamison's cases where a judge found a constitutional violation, described it in detail, and then dismissed the lawsuit because qualified immunity required it. The bill ultimately stalled in the Senate. Qualified immunity was not eliminated at the federal level. But the serious, legislative, on-the-record conversation about a doctrine that had protected Officer McClendon had reached the floor of Congress. And it had gotten there, in part, because a judge in Mississippi had refused to stay quiet while he followed the law. But the final twist in this story is not about Congress or qualified immunity. It is about Judge Carlton Reeves himself and what happened to him after he wrote those 72 pages. After the opinion went viral, something happened that surprised many people but not those who had followed Judge Reeves' career. Legal scholars, civil rights attorneys, and Democratic political observers began floating his name as a potential Supreme Court nominee. His biography was remarkable. First in his family to attend college, raised in rural Mississippi, graduate of Jackson State and University of Virginia Law, Obama appointee, only the second black federal judge in Mississippi's history. His record on the bench was distinguished, and his 72-page opinion in Jamison v. McClendon had demonstrated something rare in the federal judiciary: the willingness to say plainly what the law required him to do while simultaneously making clear that what the law required was wrong. Reeves was 56 at the time the opinion was published. Some observers noted that a Biden administration might look for a younger nominee. But his name stayed in circulation, not because he had sought attention, but because the quality of his mind and the courage of his opinion had made it impossible to ignore him. And what Judge Reeves said publicly about his own life, about growing up in Mississippi, about what he understood that others didn't, is the chapter that ties this entire story together. There is one detail about Carlton Reeves' life that closes the circle of this story in a way that feels almost impossible to have been accidental. As a teenager in Yazoo City, Mississippi, Carlton Reeves worked cleaning the office of a federal judge named William H. Barber Jr. He mopped the floors. He emptied the bins. He moved through that office, the office of federal power, of the law, of the institution that would one day either protect people like Clarence Jamison or fail them as the invisible boy doing the work that invisible boys do. Decades later, Carlton Reeves was nominated to the federal bench to fill the seat vacated by the retirement of Judge William H. Barber Jr., the exact same judge whose office he had cleaned as a child. The boy who mopped the floors became the judge who sat behind the desk. And when a black man from South Carolina brought a case about being stopped for driving a Mercedes through Mississippi, that judge who knew this state, this history, this specific kind of harm, refused to let the ruling be the only thing his opinion said. He wrote 72 pages, because Clarence Jamison deserved at least that much. Judge Carlton Reeves ended his opinion with a line that belongs in every conversation about race, law, and what America has promised and failed to deliver. After listing every name: Tamir Rice, Eric Garner, George Floyd, Elijah McClain, Sandra Bland, and more, after tracing the history of Mississippi's racial violence, after explaining qualified immunity, after ruling for the officer and against the man he knew had been wronged, after calling on the Supreme Court to do better, he wrote the final truth about Clarence Jamison. He was not committing a crime. He was not doing anything wrong. He was not a threat. He was a black man, driving a Mercedes, going home. Clarence Jamison bought a car he earned. He took a vacation he deserved. He drove through Mississippi on a highway that belonged to him as much as anyone. And an officer with a badge and a lie took 110 minutes of his life, left $4,000 in damage on his car, forced him to stand on the side of the road in the dark, and walked away without consequence. But Judge Carlton Reeves made sure the world knew his name, made sure the law students knew his story, made sure that when the history of this moment is written, Clarence Jamison is in it not as a case number, not as a ruling, but as a man who deserved better, a man America still owes. Immunity is not exoneration. Write that down. Say it out loud. Because the system that let Officer McClendon walk away from what he did to Clarence Jamison on that Mississippi highway is the same system that operates in every state, on every highway, in every moment when a badge meets a black man in a nice car and decides that is suspicious enough. Judge Carlton Reeves could not change the outcome, but he refused to let the outcome be the only word. 72 pages. That is what dignity looks like when the law fails. Share the story. Not because it ends well, it doesn't, not for Clarence Jamison, but because the truth of it matters. And stories that matter deserve to be told. Subscribe to Rollins Justice, because justice delayed is not justice denied. As long as someone keeps saying the name. All facts sourced from NPR, The Washington Post, Newsweek, Law and Crime, Jackson Free Press, Equal Justice Initiative, Federal Defender Services Office, and the published opinion in Jamison v. McClendon. Number 3:16 CV 595 CWLRA, SD, Mississippi, August 4, 2020.